All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for the webinar, Increasing Financial Stability for Family Law Clients, a QDRO training for legal aid attorneys. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. The training is being recorded. You're going to receive a copy of this recording in an email from Zoom within 24 hours. If you don't see that email, I'll drop my email into the chat just in case. Also, be on the lookout on our YouTube channel. If you are subscribed to it or you have access to it, you will see the recording posted probably this afternoon. The training was approved by the Florida Bar for one general CLE credit, zero point 0.5 technology CLE, and one marital and family law certification credits. I'll announce the CLE code towards the end of the session. I will also drop the CLE code in the chat. It will be included in the email from Zoom, and I will also include it in the YouTube description as well. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility, just let me know. This training is also being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I'm going to drop the link to their section into the chat so you can learn more about PILS. And final piece of housekeeping announcements are questions and answers. If you have any questions, feel free to use either the Q&A feature or use the chat. If you raise your hand, I cannot bring you off mute during the session, but I may be able to bring you off mute towards the end if you want to ask questions rather than post them into the chat or the Q&A. So before I introduce our speakers, I do want to I have to give a quick shout out to Tanisha Hall and Bethany Barber, our friends from Legal Aid Society of the Orange County Bar Association, because they connected me with Carrie and Louise. So thanks, Bethany and Tanisha. This is really appreciated. And, without further ado, it is my pleasure to introduce our speakers today. You're going to find their full bios, by the way, and their contact info in the materials that I'll be sharing later. So we're thrilled to welcome Carrie Holmes, the Executive Director of the Center for Access to QDROs. Carrie leads efforts to close the justice gap by helping low-income litigants secure the retirement benefits they're entitled to. She's an advocate, attorney, and tech-forward leader with deep roots in family law and pro bono work. You can find Carrie's full bio and background in the Zoom registration and the materials that I'll be sharing. Our other speaker is Louise Nixon, board president of the Center for Access to QDROs and co-founder of QDRO Counsel, a legal tech company focused on pension division. Louise has been at the forefront of expanding access to retirement asset division for those in financial distress. Her work helps bridge the gap between family law and financial justice. Her full bio is also going to be available in the materials. So without further ado, I'm pleased to pass it over to Carrie and Louise. The floor is yours.
Thank you so much, Jorge. What wonderful introductions. um, Again, my name is Carrie. I'm the executive director of the Center for Access to QDROs. My background is in family law and in family law legal aid work. In particular, I've been working with QDROs since 2018. The format of today's webinar, I'm going to be kind of taking the lead, working through the slides, giving most of the presentation with Louise, who is an incredibly experienced QDRO attorney, chiming in with her tips and tricks and best practices, both to provide you with her incredible perspective and to keep you all awake. So it's not just one voice talking at you for this whole hour. We're so happy to be here with you today. Okay, so today our plan for the hour is to quickly talk about why retirement benefits and QDRO services are an access to justice and poverty abolition issue. We're going to talk about the types of retirement plans and some governing law, jurisdictional issues between state and federal law. We're going to go over the steps in the QDRO process and then talk about what we do at the Center for Access to QDROs, which is a nonprofit legal services organization. Okay, so retirement benefits matter for a variety of reasons, but one really important feature of making QDROs more accessible is to help address incredibly astronomical rates of elder poverty in the United States. Over 16.5 million older Americans are economically insecure, and this rates of elder poverty in particular affect women and especially affect women of color, who have often, because of caregiving responsibilities, occupational segregation, all kinds of different societal factors have often been pushed into lower wage work or have taken time off for caregiving. And so receiving their fair share of a former spouse's retirement benefit is the difference between being able to make ends meet financially or not. And QDROs, coming from the family law legal aid world, QDROs have been a really big missing piece in our ecosystem for a long time. Unless you work at a legal aid where maybe you have a volunteer who is a QDRO specialist who will prepare the QDROs for you, it is incredibly time-consuming and challenging work, and often a reason at legal aids why we have to turn cases away or exclude from our retainer that we're going to deal with the retirement benefits. So being able to provide these services to ensure that we can effectuate the retirement benefit division orders in a divorce judgment is really exciting to me as a as a family law legal aid person. I actually met Louise because she was on the board of an org that I used to be at as a staff attorney and the pro bono manager, and she did all of our QDROs for free, pro bono, which was amazing. And now we want to kind of make them more accessible, really nationwide. I'm going to pop in the chat. We have a QDRO needs assessment survey that we would be really, really grateful if you would take a few minutes to complete. Because we haven't really had a resource to address QDROs for our client communities, sometimes it's not an obvious economic justice or access to justice issue, especially for funders. So we would love to get the feedback that, like, yes, this is something that we need. This is a service that we want, that our clients deserve. They should be able to access QDROs in the same way that clients who can afford a private practice attorney can, especially since for our client communities, their need for these retirement benefits can be so acute. Okay, so I want to quickly go over some terms that we're going to be using today, some terms of art. There are a bunch of different ways to kind of refer to the person whose name is on the retirement account versus the person whose name is not on the retirement plan or the retirement account. We'll probably, for the most part today, use in-spouse for the person whose, name is on the 401k plan, whose union membership or employment, got them that retirement benefit, and out-spouse for the other party. But we can also, most often you'll see the in-spouse referred to as the participant and the out-spouse referred to as the alternate payee or AP. Sometimes you also see member, non-member, employee, non-employee, retiree, and former spouse. There are kind of all different ways. Today, we'll try and stick to in-spouse and out-spouse, but we might get to participant and AP as well. Okay. Plan types and how to tell which one you're dealing with. So very, very broadly, there are three main types of retirement plans that are going to come up in our cases. There's also something called a non-qualified plan. Never seen that come up in one of our cases, but it's theoretically possible. But the main ones that we deal with are defined contribution plans, defined benefit plans, and individual retirement accounts or IRAs. Mostly we see defined contribution plans, DCPs, and defined benefit plans, DBPs. Very occasionally, though, we'll see an IRA, so we wanted to make sure to talk about that. So, what's a defined contribution plan? This is a type of retirement plan in which the employee and sometimes the employer, but doesn't have to be, makes contributions to fund the retirement plan. These are your 401ks, your 403bs, savings plans. The thrift savings plan is a defined contribution plan. 457bs, those are your defined contribution plans. And in a defined contribution plan, The account balance that you see on the statement, someone might get a statement from Fidelity or Vanguard or Charles Schwab that has, company name 401k plan on it. Whatever the amount is on that statement is the value of the plan. But that money is invested, right? The employee is going to make investment choices. Sometimes the employer makes them, but the vast majority of the time for a defined contribution plan, the employee is deciding how those funds are invested. So it's important to think of defined contribution plans, even though the statement might look kind of similar to a bank account statement. Those funds are not static, right? They're not held in a bank account. They're invested as the investments experience gains, the amount of money is going to go up, and as they experience losses, it's going to go down. So there are earnings and losses to kind of think about when we're talking about a defined contribution plan. Okay, a defined benefit plan. And here we're going to talk about kind of a traditional defined benefit plan. A defined benefit plan is what you think of when you think of a pension plan. And a defined benefit plan is not so much like a pot of money in an account, like a defined contribution plan, right? You get your statement for your defined contribution plan, your 401k, it says there's $10,000 in there. That's that value. A defined benefit plan is not a pot of money in an account. It's more like a right to receive a payment starting from when you retire, usually for the rest of your life. It's possible to, get a buyout of your pension and all these different things, but the best way to really think about a defined benefit plan is not a pot of money, but more like a right to receive a payment. Um, most pension plans have a formula about how they calculate how much that monthly payment is going to be. And it's going to incorporate a ton of different things: years of service, age, final average compensation, actuarial tables about how long someone's likely to live, all kinds of things. And usually that is paid out as a monthly annuity. Now, valuing a defined benefit pension plan is a unique and special challenge because we can't, there's not really a value to it until the person retires and we know how much they're going to receive, right? Because part of the pension calculation is final average comp, years of service, all these things, which we can't really know until they retire. Um, but if we're going to do something like an offset, the only proper way to value a defined benefit plan is with a present day actuarial valuation. So it is possible to value it, but it is not like a pot of money in an account. You have to do some additional work there because you're valuing not just the years of service and all that, but you're also valuing the right to receive that very consistent stream of income, right? That is part of the value of a defined benefit plan, is that you get that defined benefit every month. So sometimes, employees will contribute to a defined benefit pension plan. This is especially true for some public plans. If someone works for a state or a county, oftentimes they may contribute. And sometimes that pension plan will send a statement that says, here's your contributions to the plan. Don't get tricked by that because that is just the employee's contributions to the plan. It doesn't include the employer contributions to the plan. So we've had several cases. Louise and I are going to have a meeting this afternoon, actually, on a case where someone got a statement like that and they were like, oh, okay, great. This pension plan is worth $400,000. But that was just what the husband had contributed to that plan. Not at all what the employer had contributed, and not at all a present day actuarial valuation of that consistent income stream in retirement. So when people get confused by those statements from public plans, it often results in undervaluing the outspouse's interest, sometimes by several $100,000. These defined benefit plans are incredibly valuable assets because of that consistent income stream. Um, these defined benefit plans are also tricky in that if an employee does not contribute to them, which is very common for union members and for private employers, um, the in-spouse might not even know that they have a defined benefit plan. Now, sometimes they're straight up trying not to disclose it. Like I've been a family law for a long time in legal aid. Sometimes they're trying not to disclose, but people don't understand their retirement plans. You know what I mean? So it is also true that sometimes people genuinely do not realize that they have this additional retirement benefit. So this is something that gets omitted from judgments on a very regular basis because it's not disclosed. And it doesn't necessarily show up on a pay stub if the employee is not contributing to it. You know, something like a 401k defined contribution plan, we can usually see that on a pay stub, right? That we see a little line that says 401k contribution. And we're like, okay, great, this person has a 401k. But a pension plan might be less obvious. So these get omitted on a regular basis. So it's very important to think about not just the 401ks, but also those pension plans. And most mid to large size employers offer both. They offer both a defined contribution plan, like a 401k, and a pension plan. Pension plans are less common. The things that you see in the news about them are 100% true, but they are still offered by most mid to large size employers.
I just want to add, thanks, Carrie, that, I mean, these points, you're probably all thinking, well, God, do I need to learn all this? I mean, it's a lot, but this is one reason we start with this, and we're really Carrie did a great job. Thank you for explaining the difference, because in this impacts how what you look for, how you look for it. And I can't tell you in my 30 plus years doing dealing with retirement plans, because I came from being a plan attorney for half of my career, and then I have my own private practice. And the I would say half the divorce decrees, divorce judgments that we got were missing the defined benefit plan, and that's the $1 million asset. That's, I mean, for if somebody's contributed 400,000, that's a $2 million present day value. I mean, we're talking big numbers of people that they just don't get their money. I mean, it's really it's so frustrating. I started doing QDROs for free with the nonprofit in California in 2004, and when I was a plan attorney, and I had no idea, being a plan attorney, that there was such a huge gap, that there were so many people, especially living below the poverty level, that weren't getting access to what they were entitled to by law, because one party's working, the other party's not. And as I began doing more, and I just kind of incorporated it into my law practice, it was almost overwhelming to think that this is going on all across the country. And that's one reason we started the Center for Access to QDROs, because I thought before I retire, because there's no good resource. I mean, there's some, but they're not great. They're hard. And who has time to look through them? How do we provide access to QDROs so that people are able to get what they're entitled to? And that's one reason that we're doing this, and that we've been able to get tremendous support from the people starting in California and now Nevada and hopefully Florida, because we really see, I mean, obviously this is a need that exists. So I'm getting on my platform here, but I couldn't take it anymore because of the lack of access to QDROs and the courts, and the lack of knowledge by the courts and the judges and the family law attorneys because of the lack of access. So anyway, that's my little, it's important to know the difference between these two and to spot them, because if that's all that's done, it makes a huge difference in at least cementing the rights of the outspouse to whatever retirement plans exist in the divorce decree.
Thanks, Louise. Okay. I want to briefly talk about something called a cash balance plan, which is a type of defined benefit plan. These are becoming more and more common because they are less expensive for employers to maintain. And we're seeing traditional defined benefit pension plans sometimes converted into a cash balance plan. So sometimes I describe these as like a defined contribution or defined benefit plan wearing a defined contribution plan's clothes, because it is a defined benefit plan, but it can look very similar to a defined contribution plan because the employee is contributing and the employer is contributing, and there's like a specific dollar amount. But essentially, it is those contributions are invested and they can be paid out either in a lump sum, or you can what's called annuitize them and pay it out month by month in the same way that a defined benefit plan is paid out. So these are more and more common. They function pretty similarly to a defined benefit plan, but wanted to kind of put them on your radar as something that we're seeing more and more often. Okay, so quick comparison again between a defined contribution plan, 401k, 403b, 457, savings plan. Those are all examples of defined contribution plans, and then a defined benefit plan. In a DB, a defined benefit plan, the participation is usually automatic and mandatory. So that's why these often go undisclosed. The employee spouse, the in-spouse didn't necessarily sign any paperwork, might not see a deduction from their pay stubs, so they might genuinely not know. Those investment decisions are professionally managed for a defined benefit plan. In a defined contribution plan, the employee is going to make all the investment decisions and they bear all the investment risks. So if they make terrible investments and the stock market craters, then that's what happens to their 401k as well. For a defined benefit plan, some portion of those benefits are federally guaranteed by an organization called the Pension Benefit Guarantee Corporation, which is a federal organization. So even if someone tells you that their pension was terminated, or the company went out of business, or they no longer have their pension, there may still be a benefit guaranteed by PBGC. So don't take that at face value either, right? There are plenty of pension plans that have been terminated and then trusteed to PBGC, and those benefits can still be paid out, and we can still do a QDRO for them.
I think a common, well, what we see commonly is a participant not knowing, or don't take at word value when either party says there's no defined benefit plan, because especially for a larger company, there probably is, and that's like the $1 million asset that's missing for sure. It's so common for a participant to say they don't have a defined benefit plan, but if they're employed, or if they were employed for at least 5 years, they have one. They definitely have one. And so it's really important to take, the extra step, which the center can help you. We have a database of access to a database of over, over 1 million plans, and basically all the plans that exist, especially the private plans, for any private company that exists. We're able to track and figure, like a Google search, find the plan that are offered, the plans that are offered by this company, whatever the company is. So that is a big just first step in figuring out what a party has. You really don't need to do much, which I think Carrie's going to get into. There isn't much discovery that has, as far as defined benefit plans are concerned, because we know that they have them, and we know what the names are, and we know how to divide them. So it's pretty easy to actually divide these plans. They seem complicated, but it's easy to divide them in divorce once you identify them.
Louise. Okay, so I want to briefly talk about IRAs, which occasionally crop up in our cases. So there are kind of two types of IRAs. The first type is one provided by an individual, and these are, again, held by financial institutions. So you might see somebody's Charles Schwab IRA, Fidelity IRA, Vanguard. They're at a financial institution, and it is funds that are invested in the market. So kind of similar to a defined contribution plan. So an individual provided traditional IRA is funded with pre-tax money. So it's a payroll deduction that you can send out to your IRA. What we see most often at the center are rollover IRAs, which means somebody had a 401k or some other kind of defined contribution plan for an employer where they no longer work, or that employer went out of business or something. They needed to do something with their funds that were in that 401k plan. And then they put them into a rollover IRA so that they, can do that rollover without making a withdrawal and paying taxes and penalties. An IRA, we sort of refer to every retirement benefit division order as a QDRO for purposes of our trainings because that's how everyone talks about it. You talk about an IRA QDRO. Very technically, that's not what a division order for an IRA is called, or some other division orders as well. Very technically, you don't have to have a QDRO for an IRA if the language in your judgment or decree is specific enough. But if we say, this person's going to receive 50% of the marital property in the IRA, that's not usually specific enough. So we often end up having to do a separate IRA QDRO, which is called a 408 order, to divide that. A Roth IRA is funded with post-tax money. So money where, you've gotten your paycheck, all your taxes have come out, and then whatever your net is, you're going to put some of that into a Roth IRA. And people do that because then the investment gains are non-taxable. And then when you make a withdrawal from your Roth IRA in the future, that withdrawal is also non-taxable because you've already paid the taxes on it. I have a Roth IRA. I think they're pretty great. There are also, I have not seen these in our cases, but just want to kind of put them on your radar just in case you have like a really savvy opposing party who is self-employed. There are employer provided IRAs that are SEP, SARSEP, and Simple. Each of these, they're usually for self-employed people as a retirement savings mechanism. So you might see them. We haven't come across them too often, and the division method is very, very similar. One thing to know for an IRA is that, if we're dividing a 401k or something, we can say, all right, we're going to take 50% of this 401k as of, whatever marital period end date is relevant for your case, January 1. We're going to award the outspouse 50% plus any earnings or losses between January 1 and whenever the plan actually processes the QDRO and does the division. An IRA can only be divided as of that date in the future when the plan actually processes the QDRO and divides it. So we can't put in the IRA QDRO, 50% as of January 1 plus earnings and losses. We have to put a percentage or a specific amount as of that date in the future. So that can sometimes make IRAs a little bit complicated because we might need to do a calculation or something to determine the right amount or percentage to award. Okay. How do you figure out what type of plan you're dealing with? So one important thing to do is to look to the plan name for some clues, right? Most defined contribution plans are going to say 401k or savings plan or something in their name that's going to give you a clue. Cash balance plans also tend to have cash balance in the name, so that can be pretty helpful. Sometimes, and I'm not sure why, plans will have a name that is misleading, right? So recently I was working on a case with a union plan and it was called the Union Name Pension Plan. And I was like, awesome, a defined benefit plan. That is great. I get the documents from the union about it. That is a defined contribution plan, just like it's just like 401k. It's called the pension plan for what reason? I don't know. Just to make me confused, I guess. So that is a great hint to look at the plan name, but it's not always 100% accurate, right? There might be many reasons why a plan might be called whatever it's called. That's not quite right. So as Louise talked about, one of the things that one of the services we provide is plan research. So we can look up by the name of the employer every retirement plan offered by that employer, which is so cool. Just as like as a family law attorney, that's already saving me like several hours of work, just being able to like put it in the database and get back every plan offered by that employer. And then that also includes the type of plan that it is. So even if it's, whatever pension plan, I can see on our software that it is a defined contribution plan, so I won't get tricked. Okay. What's the purpose of a QDRO? What are we doing with these? What all can QDROs accomplish? Because I think QDROs can do a lot more than we realize as family law attorneys. So one question we get asked a lot is, do I always need a QDRO? Do I have to? What plans have to be QDRO'd, which is my favorite verb, versus what plans don't have to be? So in general, if a retirement plan is going to be divided as part of the divorce, then you've got to have a QDRO to actually effectuate that division. And in general, each plan, even if offered by the same employer, is going to need a separate QDRO. So even if somebody works for one employer and that employer offers a pension plan and a 401k, in most cases, we need to do a separate QDRO for the pension and a separate QDRO for the 401k. Some plans will accept one for both, but that's fairly uncommon. Most plans require two separate ones. And remember, the plan is not trying to be difficult. Well, most plans are not trying to be difficult. They are prohibited from paying anyone who is not the plan participant unless they have a QDRO. And this is a system that Congress set up, right? This anti-alienation provision is what it's called, to prevent the plan from making unilateral decisions about, taking an in-spouse participant's benefits and paying them out to cover company expenses or to cover other things. Congress really wanted to encourage those retirement savings to stay as retirement savings. So they put up a fair number of barriers to paying those benefits out to other people. I think it's maybe unintended, but a negative consequence then on the outspouse, who maybe has less resources, is perhaps less financially sophisticated, a survivor of abuse from the other party, often including financial abuse, that then they now have to deal with this additional extra challenging process for which we don't have a ton of resources in legal aid. Okay. So one great benefit of dividing with a QDRO is that the outspouse, the alternate payee, they get their benefits paid directly by the plan. So that's sometimes a worry for some of our clients. The other person, my former spouse is going to get the benefits and they'll do whatever and then pass me my share. No, it's almost, sometimes I compare it almost to like a wage garnishment order. Because it comes directly from that third party, that employer, that plan, directly to the outspouse. And the outspouse is going to pay their taxes on benefits received under the QDRO. So it's kind of setting up for them their own 401k, their own, kind of pension payment. They get it directly with the plan. Okay. So QDROs can do a lot more than just divide community or marital property. And some of this I genuinely did not know about as a family law attorney until I kind of got more into this QDRO world. So depending on the type of plan and whether someone's retired, so all of these are really fact specific, right? Because each retirement plan gets to set its own procedures and decide what it will or won't accept in a QDRO and what language it wants and all those things. You can actually use a QDRO to satisfy maybe an equalization payment that's due in the judgment. You can use a QDRO to collect child support, or alimony arrears. And depending on the type of plan that's at issue in the case, sometimes we can collect those arrears as like a lump sum, and get a really significant amount of money for our clients, which is my favorite thing. I love that. That's really cool. It's really great to, be able to get your client a significant sum of money out of a retirement plan. We can also secure life insurance beneficiaries. So sometimes we see opposing parties who have some kind of life insurance benefit with their work. And so we can, send a QDRO essentially to the life insurance company to require them to keep your client, the outspouse, as the beneficiary of that life insurance. And then there's also something called a qualified medical child support order, which can secure health insurance coverage for children. So all of these things can be done with QDROs that I think we don't necessarily really think about beyond just like, oh, we have to divide the marital property in it. But it's actually a really powerful tool that can do a lot of different things. And all of these contribute to our clients' financial stability. Okay. So I want to very quickly touch on the governing law and some jurisdictional issues. The kind of key takeaway here is a flashback to your Civ Pro class, which is the feds are going to win every time over our state marital property law. To the extent there's ever a conflict, the federal law is going to win. So governing law for retirement plans kind of falls into two buckets, whether the employer is a private employer, a private company, or a public employer. That includes states, counties, cities, federal, military plans. Important to note, both private and public employers can offer defined contribution plans and defined benefit plans, right? So it's sometimes I think there's a misconception that like, oh, someone has a pension, they must be a public employee. Private employers can absolutely offer pensions, and public employers absolutely offer 401ks. Many, many employees of either type of employer have both types of plans. So plans offered by private employers, though, are governed by a federal law called ERISA. And we can send a site to where ERISA is in the United States Code with the materials. Plans offered by public employers are governed by state law about, state employees, city, county employees, and then federal employees and military members. They're governed by federal law, but not ERISA. They're governed by additional benefits law specifically about federal and military employees. Okay. Both types of employers, both plans require QDROs to divide. So I think sometimes people think, oh, QDROs, that's an ERISA thing. And that is true, but we still need a retirement benefit division order, a DRO, for a public employer as well. Okay, so who has jurisdiction? What do we do if there's a conflict? And the answer is federal law supersedes. And especially for the private employers, ERISA specifically says that a QDRO cannot make a retirement plan do anything that is inconsistent with that retirement plan's own procedures. So that's why QDROs are a challenging area of the law, right? Because you can't just make like your QDRO template. Like I've got my 401k template and I'm going to use it in every case. That's great. I figured it out. Unfortunately, no. You need a QDRO that is specific to the exact plan being divided and the facts of your specific case. So if there's any conflict between a state court, divorce judgment order and the plan's requirements are going to control. So if you want to do some like unique, interesting division and the plan won't allow it, the plan is the boss. The plan gets to kind of tell you what is and is not consistent with their procedures. That doesn't mean that we never push back, right? If their procedures are vague or not clear, but for the most part, the plan gets to decide what's going to be in the QDRO and what methods of division are available. and you just won't succeed in trying to enforce your state court order if it is inconsistent with the plan procedures or that federal law.
I mean, it's kind of scary when you think about it, because I remember even as a plan attorney, we get these divorce judgments that were asking for the plan to do something that wasn't possible, like a lump sum payout for a defined benefit plan, which in most of them, the traditional defined benefit plans, that will not be acceptable. Especially we see that. That's, I think, the most common issue is somebody will do some sort of global equalization offset in their divorce decree, and then have it be paid out of as a lump sum out of a defined benefit plan, which isn't possible. And I remember, as especially when I represented a plan, I'd be like, sorry, you got to fix it. And I mean, it was kind of fun. You basically, as a plan attorney, you're kind of a judge in a lot of ways, because you're not going to follow a state court order. And that, what are they going to do? If they go to court, they're going to lose. So because federal law will preempt state law. Now with the state plans, those especially public employee retirement systems, the teachers retirement systems, they have their own regulations. They have their own laws on the books, and those can't, if there's some conflict between that state law and the division of marital property, that the plan law is going to supersede that. So it's a big problem. It's a big dance almost between for people who are dividing the retirement plans, which I've been doing for so long, of coming up with the fairest way to divide these things, to divide these retirement plans, to try and oops, sorry about that. To try and divide these as fairly as possible, and get as close as you can with what the marital property division actually is in that state, and what they're asking for in the divorce decree.
I think it's very unusual as a lawyer to send someone like a certified copy of a judgment that has orders signed by a judge, only for another lawyer to be like, no. No, thanks. I am not going to do this. But that is absolutely allowed, and that is part of what makes QDRO so challenging, is that every QDRO has to be consistent with that specific plan's procedures. Okay. So let's talk about the QDRO process. And I think as family law attorneys, it is often received wisdom that the QDRO process starts after the judgment, right? Oh, I've got my judgment. Now it's time to do the QDRO. We would like very much to encourage you to start thinking about the QDRO process as happening concurrently with that family law case that you're working on. So we want to think about it as in kind of 3 steps. So pre-trial, as soon as you get the case, there is a document called a notice of adverse interest, which is essentially a notice of pending action. And, in most states, there's some kind of order that goes into effect as soon as a divorce is filed that says, okay, nobody should be messing with money, moving money around, changing insurance beneficiaries, doing anything out of the usual with the party's funds. But the retirement plan doesn't necessarily know that a divorce has been filed, right? The retirement plan has no idea that a divorce has been filed. So if the participant, if the in-spouse shows up at their HR's office and says, I want to withdraw all the money out of my 401k, I don't care that I'll have to pay taxes and penalties and destroy significant value. I want to do that right now. The retirement plan has no reason not to allow that, and actually kind of has to allow that because it is the participant's money, unless we put the retirement plan on notice that someone else, the outspouse, has an interest in these retirement funds. Most retirement plans, not all, but most, will put a hold or a freeze or a withdrawal restriction, something on that retirement plan once they receive a notice of adverse interest. Now, that hold doesn't last forever, right? Usually it depends plan to plan, but most plans will put that hold on for about 18 months. So that can give you time to kind of resolve these issues. The plans that won't, that are like, oh, I'm not interested in your notice of adverse interest from your state court case, the federal retirement plans and the military retirement plans, they're like, we're federal, we're not interested in, in your little state court thing. So those you can't put a hold on. But you know, a 401k from a regular employer, the vast majority of them are going to respond to a notice of adverse interest and put a hold on the plan. We also want to think about whether any discovery is going to be needed. It's funny because I think as family law attorneys, you think, oh, the pension plan is really scary and hard, and that's the really challenging one. As your resident QDRO nerds, I can tell you the pension plans are actually the easier ones to deal with. It's the 401ks, the defined contribution plans, and the IRAs where we tend to need more information because maybe somebody has a premarital interest in that has to be valued, or they did a rollover from, you know, a plan that they had prior to the marriage that needs to be backed out of the total value. So do we need any plan statements? Do we need any information to actually get the QDRO done? And then the language that is in your judgment is incredibly crucial because what the QDRO does is effectuate the orders in the judgment. So if the orders in the judgment are vague, they're not clear, they don't protect your client, sometimes there's not much we can do in the QDRO to resolve that. And I'll talk in a second about the risks if that judgment language is not clear. And then ideally concurrently with the judgment or after it, we'll do kind of the meat of the QDRO process, which is drafting that QDRO, sending a draft of it to the plan. And most plans will take a look at a draft. And if they will, we always want them to, because the worst thing in the world is to go through the whole rigmarole of getting it entered by the court and all of that, only for the plan to reject it. So if they will take a look, we always want them to. We get that pre-approval from them that says, yes, once this becomes a court order, we'll comply with it. The client and the opposing party will sign the QDRO. There's not a requirement that QDROs be stipulated. That is a pretty common misconception. There's no federal requirement, no plan requirement that those be stipulated. Most of them are, but you know, you may have to do a motion to get that QDRO entered. The judicial officer will sign it, and then you send usually a certified copy of the QDRO to the plan for implementation. Okay, we do have a question in the chat. Do we have any insights when dealing with military retirement orders and the survivor benefit plan? Is there much wiggle room with which spouse pays the SBP? We would love to come back and do a whole webinar for you just on military retirement division, because we could do like a solid 90 minutes on it. The important thing to know about the survivor benefit plan is that so I'm going to answer this question. I'm not going to provide all the background for everyone because I want to keep us a little bit on track. The important thing to know about the survivor benefit plan and who pays for it is that when DFAS, you know, they calculate what the military pension payment is going to be, they're going to take the cost for the survivor benefit plan off the top and then divide the benefit between the military member and the out spouse. So if we, you know, get a judgment that says the out spouse has to pay for that survivor benefit plan, it's super complicated. It requires a whole actuarial recalculation of what the out spouse's share should be, because the only way DFAS takes that payment is off the top. So most of the military QDROs that we prepare, we have and we suggest that the parties share in the cost of the survivor benefit plan. Because if the out spouse dies before the member gets their whole benefit back. And so then as kind of a consideration for that, if the member dies first, then the out spouse gets that survivor benefit plan. So that's the thing to know about who pays for the SBP, is that it becomes exponentially more complicated if you try and assign it to one person. It is so much simpler from every perspective to make it the parties share it, because the only way DFAS will do it is take it off the top. I hope that answered your question.
Yeah, and we would love to do a military talk, because I know there's certainly a lot of retirees and military bases in Florida that could benefit from that. And that's an issue for sure. And that issue has been litigated actually on who pays for the cost in California, but we don't have time to go into all of those details. But there's nuances to it that can help in what decisions you make with regard to that.
Okay, so our one thing we would love for you to take away from this is that the very best practice is to have the QDRO done at the same time as the judgment. I know sometimes that's not possible, and it would be kind of a change in how most of us practice, but that is really the best practice, because there are a huge number of risks, especially for the out spouse, if the parties wait, and the parties do wait, right? Even in private practice clients, you know, when I first started, I was in private practice family law. They wait. They're tired of their divorce. They don't want to deal with the QDRO. They wait 5 years, 10 years, 20, 25 years to get
What
their
was what
QDRO done.
we just got from like 1987, something
Yeah.
like that. All right.
Yeah, and for our clients,
Like,
especially, you know, coming up with the funds to pay for a QDRO causes that delay. So that's part of and causes that delay, and then leads them into all of these potential issues. So the biggest issue that I want to cover is the issue of remarriage and then death. So if the divorce judgment or decree says something like this person's going to get 50% of the marital property in the retirement plan, which is very common language, and it doesn't say anything about survivor benefits, or it doesn't put in the correct name of the plan, that can cause a lot of problems. So we see a lot of divorce judgments and decrees that say, you know, husband's Fidelity 401k plan is going to be divided. Well, I don't know how to tell you this, but Fidelity has about 1 million 401k plans that they administer. That's not the name of the plan, right? The name of the plan is usually the whatever employer 401k plan. So it's really important to get the name right in the judgment, and then also to include a specific award of survivor benefits, especially if there's a pension plan. Because if there's a delay between when the judgment is entered and when the QDRO is done, and there's not anything specific about survivor benefits in there, if the participant remarries, right, before that QDRO is done, and they remarry and then they die, it is possible that that survivor benefit, right, the continued pension payment after the participant dies, that survivor benefit might go to the new spouse. Right? Your client maybe was married to this person for 30 years. They got divorced, that person remarries, and then they die. They maybe were remarried for 2 months. It would work a tremendous hardship and a tremendous injustice for that survivor benefit to go entirely to that new spouse. But that has happened, and that does happen if the judgment language is not clear enough. Those are the very worst calls that we get, because it is almost always an older woman, and she is absolutely crying by the end of it, because there is often not a legal remedy for us to resolve it because the judgment language was vague and unclear. So that's part of why we really, really recommend getting that QDRO done, ideally at the same time as the judgment.
and even if you don't do that, the judgment language, and I think Carrie we try and reiterate this over and over again. If you do one thing to change what you're doing, or if you're already doing it, keep doing it, is put in just a simple sentence to include, if it's just a very general award of the community property, the marital property, or that one sentence saying this award includes any survivor benefits, or something. We actually have some good language that we can give you that can help to secure that interest, because as long as it's in the divorce decree or divorce judgment, you can get a QDRO after death, and you are protecting your the out spouse's interest in that and right to receive that that portion of the pension. Otherwise, it's impossible. And this has all been litigated throughout the country. It's not just it's been in multiple states, and it was most recently litigated in the Ninth Circuit. But it's not. It was litigated in the Fifth Circuit. So this is the common outcome that happens, and most family law attorneys and judges don't know the ramifications. A simple clause in your divorce judgment will protect the outspouse's interest, because to allow for a QDRO to be done post death to preserve that interest. It also will protect if the participant tries to retire, and then with a subsequent spouse, will protect that interest too, because then that also cuts off survivor benefits. We also have a whole talk on death and QDROs, one of my favorite subjects. So we can deep dive into all that as well, but at a later time. But just a short clause will make a huge difference. And if you don't have time or aren't able to deal with a QDRO. And I don't want you guys to get freaked out too about, oh, this is too complicated. It's not. Because of the experience of, and because we've been working with a technology company there are patterns, there are ways that we've been able to divide and qualify, certain plans need this type of QDRO, other plans need this type of QDRO, and there's similarities between all the public plans. So you're able to, sort through those. So it is doable. It isn't doable on a large scale without technology. And that's one reason that in 2017, I've been working on this for a long time, that's the only way that we can be able to facilitate the access to QDROs is through the use of technology. Otherwise, it's too formidable. That's why it has never been done. The law to protect the outspouse that came about in 1984. So this has been going on for a long time.
Thanks, Louise. So at the center, what we do is we work with legal aids, and right now we are working across California and Nevada, and hoping to expand nationwide, since most of this is federal law. And we provide technical assistance specifically to legal aid, self-help center, family law facilitator staff, and the clients that they serve. So we provide a bunch of different types of services beyond just QDRO drafting, although of course we also draft QDROs. And we do all of this utilizing technology. So Louise and some others started a technology company called QDRO Council that kind of automates the drafting of QDROs, and donated a license to the center. So we utilize that technology to prepare all of our QDROs. The joke that I kind of say is that the software is kind of like having Louise in your computer screen, which is the best. So the technical assistance that we provide includes plan research, which is, I think sometimes because QDRO people really know all the different plans, they forget how miraculous that is as a family law attorney, to be able to go in and put in the name of the employer and come up with every plan offered by that employer. I cannot even tell you the number of times that we have found undisclosed plans where the legal aids client has a benefit, that the money that is theirs that should belong to them, that would not otherwise be divided because the plan was never disclosed. We prepare notices of adverse interest to kind of put a hold on those benefits. We assist in preparing judgment language that is specific to the type of plan. So military judgment language looks different than 401k judgment language that's specific to that type of plan and the case. We do calculations. So if somebody has a premarital interest in a 401k, we can calculate it. And then, of course, we draft QDROs, and all of this is automated, so we can do it really fast. A lot of QDROs I can draft in 10 minutes, which is, again, so cool because it's all been coded on the back end. What does this specific plan require in their QDROs? So as I go through and I answer questions, it's going to give me a QDRO that is specific to this plan, that is, really high quality work product, because it's Louise's work product. So it's very cool what we can do. I'm not going to get into too many details of the types of calculations that we can do, but we can do that present day actuarial valuation for a pension plan. So we do those all the time. If there's like a house and a pension that needs to be divided, we can do that valuation for that pension. We would love to work with you in Florida, and make our services available to you and your clients. Um, we can help a little bit right now, but we would love to, explore any kind of grant opportunities with any of you so that we can help support you, and make these services available to you. I know how hard it is to work in legal aid and know that your client deserves and should have their fair share of retirement benefits, and just not having the resources to be able to effectuate that for her. And we would love to be able to come in like your cavalry and, provide these services and really get it done and get your client the money that's hers, that belongs to her, that a judge has ordered she should have, and make sure that she actually gets it. So please reach out. You have our contact information. And if there are any questions, we'd be happy to answer them.
All right, great presentation. There were some questions that were coming in that were answered as we were going through. I did see somebody raise their hand. I can bring them off mute. Bethany, let me know. I can bring you, I'm gonna allow you to talk. So if you want to talk, go ahead and unmute yourself.
Oh, hi, Bethany.
Hey
Bethany's the
guys,
one that
thank you
connected
so
me with
much for
Carrie.
being
So
here. I appreciate it so much. Yeah, just a general thank you so much. I know on a statewide level, this will be an agenda item at an upcoming Florida Civil Legal Aid Association meeting to talk about if there are any next steps and what the lay of the land is. Because while you all are not in Florida, I'm sure you know that Escambia County behaves much differently than Monroe County, as far as the landscape and what the courts are doing. But there is a huge need. We're so thankful that you're in this space and exposing many of us to something that we've not had the opportunity to really do before. So this is just a general thanks, and I'm looking forward to connecting with you in a few weeks.
It's awesome. You know, Bethany, we're really excited too because we just got additional funding from the California State Bar to do what we call a judge's portal, but it's really what is the name, Carrie, that we need to call it?
We're calling it a virtual bench guide because Portal
Virtual
made
bench
made some
guide.
of the judges nervous.
Because we know what judges are up against too, and you've got the pro per client showing up in court saying, help me please, and the judge has 5 minutes with that person and they can't possibly get through and understand, and they're in the same boat. They want to understand, and they're the judges. We just were at a conference for where there are a lot of judges, and they are so excited about this because it kind of goes hand in hand with the work we've been doing with all the legal aids and the self-help centers, to be able to get information quickly to the judges, and also it'll trickle down obviously to the legal aid staff. So we're really excited about that opportunity as well. It's wonderful that we've worked out a lot of the kinks of how we can help directly with all the legal aids in California, and so we really have some good ways to be able to help, and we really hope that we can do that with Florida, which is in some ways so similar in terms of what we see and what we're dealing with in California. We see that in Florida too.
You hit on a bunch of things that resonate with us, particularly family law attorneys. I think all of the family law practitioners can tell you that they are also educators with the judges, and this is something that we can all stand to learn. So thank you so much, and Jorge, thank you as well. You're always a pleasure to work with.
we do have one more question here. I'm gonna read it out loud for the benefit of the audience. What can we do for pro se individuals when we advise them regarding retirement accounts and they don't qualify for full representation or do not have the funds to hire a private attorney?
Yeah, that's exactly the gap that we are trying to fill, right? Because there's been nothing available for exactly that profile of client for a very, very, very long time. So that is exactly what we do. You know, in California and Nevada, we're accepting referrals from legal aids in exactly those kinds of scenarios where we work directly with the pro se litigant to prepare their QDRO, and we get the pre-approval and then pass it off to them with instructions about getting it filed with the court. So yeah, that's exactly the gap that we want to fill and that we can fill.
Right. I know we're a little bit over time and I don't see any other questions. I dropped the CLE code into the chat, but I'm gonna read it out loud. It's 2502569N. The code, a copy of the slides and the materials are gonna go out via email as well. I'll include them in the YouTube description. Please fill out that survey that with the link that was shared in the chat. I also will include it in the materials and it will go out via email. So before we wrap up, I'm gonna share a quick story. When I met Carrie, my story was one of my first calls probably 9 years ago was from a client telling me, "Can you help me out with a quadro?" And I'm like, "Yeah, absolutely, I can." And I put the client on hold and I Googled what is a quadro. I had no idea what it was. So I almost wish Carrie could time travel and Louise could time travel back to 9 years ago and maybe help me out with figuring out what a quadro was. I totally remember the challenge with not being able to assist clients with these type of issues because they were overly complicated. So it's really nice to see you bridge this gap that we definitely need in the legal aid community. So I don't see any further questions. I just want to take this opportunity again to thank everybody for joining us here today and Carrie and Louise for this amazing presentation. And we're looking forward to continuing to collaborate with you. Thank you.
Thanks. Thanks, Jorge. Thanks, everyone.